Welcome to week 11 of Law Office Procedures. This week we're going to take a look at technology in the law office. Now let's talk about some hardware trends. I am old enough and have been practicing law enough that I remember a time when attorneys did not have computers in their offices at all. And we had legal secretaries and paralegals who had typewriters. That is a thing of the past. But right now, just about everyone working in a law office in any type of a professional capacity, the legal assistants, the paralegals, the attorneys, the office manager, everyone typically has a computer. It could be a desktop computer that is left at the office, or sometimes folks will have laptop computers, as many of you may do in jobs that you already have, where you bring your laptop home if you so choose and are permitted to do so, and you bring the same laptop back into the office and plug it in to work on while you're there. During the COVID-19 pandemic, many more people, as I'm sure you know, started working remotely or had to work remotely for a period of time. So laptop computers, for the most part now, are very widely used as the primary device to conduct work, and that includes legal work. We all also have remote access software where folks are able to take your laptop home, if permitted to do so, I must stress, and you have remote access where perhaps if there are certain safeguards in place, you're able to log in to your work account and you can see all of your documents and have access to all of the systems just as though you were sitting at your desk at the office. It's very, very important to assure privacy whenever you're working remotely. For example, I certainly can't take my laptop to a Starbucks and sit there and plug in for all the world to walk behind me and see what's going on my laptop. I often take my laptop with me when I go to the courthouse. If I have some downtime in between hearings, I can get some work done, but I need to make sure that I go to an area of the law library where I am alone and nobody can see what's going on behind me. I can't sit in the hallway and do work on my computer where people can see confidential information on my screen. If I have my computer out in the hallway when I am at work, I am working on something that is not confidential, perhaps a PowerPoint for this class. I cannot deal with anything confidential where folks can see it. And if you are bringing a laptop home and you are permitted to have remote access to your work-related files from home, you also need to be careful that your housemates, whether it's family or roommates, they cannot see what you're working on. Remember that the privilege that surrounds the relationship between the attorney and the client that extends to you, the paralegal, that doesn't mean that your family and your friends and your housemates are all in on the confidential information too. So you have to be very, very careful. And while the expansion of remote access has certainly made the job easier, it's made the protection of confidentiality much more of a challenge. So that's something you really have to keep in mind. Most law offices use Microsoft Word. A few still use WordPerfect. I'm sure you're familiar with one or both of them in this day and age. You're going to have to adapt. If you're not familiar with the one that is used by the place where you have an internship or a job, and usually these two systems are fairly user-friendly. Most law offices and legal departments will have a shared drive so that you will have access not just to the work that you're dealing with and your particular assignments and projects, but you'll have access to see maybe not all, but at least some of the files and the work product of others in the law firm or the legal department for which you're working. Just be sure that you are adhering to whatever the norm is for your law office. This is not the time and place to use some kind of interesting font because it looks cool or because it's all the trend on social media and on different posts that you use in your personal life. It's not a time for calligraphy or anything like that. Times New Roman at the 12-point font is commonly used for legal documents, so make sure you're not trying to be too creative when you're drafting documents. When communicating by email, most law firms and legal departments in this day and age have a Microsoft Outlook account, And as a paralegal, you will be given your own email address within that work account. Now let's go over some rules for your etiquette, or as otherwise known as netiquette, for when you're using work-related email in the legal setting. Never, ever, ever assume that your email is private. This is most certainly not the account you use to deal with your March Madness pool with your friends, or to send information or communications with your family or your significant other. Absolutely positively not. So you're not going to use it to communicate with anyone or anything for personal reasons. I can tell you that as an attorney, the first thing I see on my laptop when I log on is a warning reminding me that this is a work computer, that all of my communications are to be used for work-related purposes, and I know full well that even if I permanently delete an email from my work email account, it's still stored forever. So be very, very careful about this. Do not use this email for any personal reasons. Never, ever, ever give your user ID or your password to another person. Lots of problems with people hacking or sharing information that shouldn't be shared, especially in this type of a setting where everything we do needs to be in keeping with confidential documents protected. Keep your messages short and to the point. You do not need to ramble on and on and on and on. Just short and sweet and to the point. You don't need to provide any information that is not necessary for the communication that you are sending at that point in time. Edit quotations. You're not going to quote something for 2 paragraphs. So as I say, just keep it short and to the point. Limit your messages to one subject or one topic. For example, if you are emailing a paralegal in another law firm talking about setting up depositions, you also don't want to get into when you can expect to provide responses for documents that they had requested, and scheduling some kind of a site visit. Why? Because things get lost in the shuffle. Just deal with one topic. Include your signature and your contact information at the bottom of the message. And this is true even if you are dealing with another office that you deal with routinely. Just it's professional, and that person needs to be able to know exactly who they're dealing with and how to get in touch with you at a moment's notice without pulling up some old emails or Googling your law firm. Make sure your signature and your contact information are at the bottom of every message. Do not use shouty capital letters. It's not professional. It comes across as being very immature and conveys a message that you don't really want to convey. It is not appropriate to use shouty capital letters in a legal setting. And this is true even if somebody else does it. Doesn't mean it's right and doesn't mean you should do it too. When someone else stoops to an unprofessional level, you don't need to do that as well. Maintain your professionalism. And again, never use your office email for personal communications. That goes along with don't ever assume that your email that you use for work-related purposes will ever be private. Continuing with our netiquette when using email in a work-related environment in the legal world, be very careful with humor. You may be a very funny person and people may appreciate your sense of humor, but be very careful because it's not always taken well on the other side, and you really should keep that out of an email. Remember, once you put it down in an email, that exists out there forever. Don't use emojis. Again, maybe fine for your text with your friends and your family members, not appropriate for a legal setting. Think before hitting reply all. This is really important, especially when we're thinking about attorney-client privilege. There might be that one person who was included in the email to you that really shouldn't be seeing this information. So be very careful before hitting reply all. Avoid using acronyms unless you're certain they're appropriate for the situation and that they will be understood. FYI, for your information, is something that's pretty much universally accepted. But I can tell you that it's actually kind of funny. Years ago, an older attorney with whom I worked did not understand what LOL meant. Instead of laugh out loud, he thought it meant lots of love. So be careful. Sometimes if you use acronyms that you think everybody in the world understands, that recipient might really not be clued into exactly what that means. So be very careful and try to avoid using acronyms. Clearly identify yourself, your position, and your client. When you send a communication on behalf of the legal department or the law firm with whom you're working, with permission of course, you want to make sure that the person on the other side knows exactly who you are, that you are a paralegal, so they're not going to try to engage in communication with you that you're not allowed to engage in because you're not an attorney. You also have to be very clear who your client is. And that's important because you don't want them to misinterpret something and you're getting information you shouldn't have. And also, it really does not make you appear to be on top of things if you just kind of assume that if the recipient is getting communication from you, they must know it's about the Johnson case or the Smith case. So that does not make you come across as very professional, and it doesn't look make your email look to be very well thought out. Make sure you do copy everybody who should receive a copy of this, but again, be careful not to overuse it. Check your spelling and your grammar, again, to make sure you come across as professional and on top of things. Don't send an email unless you would be comfortable with it being used as a court exhibit. You've heard the old saying, dance like no one's watching. Well, email as though it will be an exhibit in your trial. Once it's in an email, it is there forever. There are many different available software programs that are out there that assist people in the legal profession. Document assembly. I remember starting out as a young associate attorney when document assembly meant myself, some other new attorneys, and a bunch of paralegals in a room getting tens of thousands of pieces of paper, and we had to go through them and assemble them in a way that made sense, that documents dealing with certain time periods or certain issues were labeled and cross-referenced, and they were placed in a system that was easy for the attorneys and the paralegals to find when they needed to pull certain documents after a ton of documents were dumped upon us. Now there are actually computer programs that help with that, and they've really made litigation much easier. Metadata removal. Much of the document production done nowadays involves providing copies of documents that have been stored electronically. And as anybody in the computer world knows, documents come with a lot of metadata, who created it, who viewed it, who drafted it, the second draft round of revisions, etc., who was the last person to make a revision to it. And many times we are asked to and should remove the metadata before we provide those electronic copies of the documents. Document and records management, again, organizing things in a way that makes sense, in a way that they're easy to find. PDF creation and editing and redacting. So quite often we need to take a Microsoft Word document and turn it into a PDF so that the recipient cannot change anything that's on it. And editing, redacting, that is something that my paralegals have to deal with quite often. If we are producing documents and certain bits and pieces of information by law cannot be provided to the other side, there's a computer program that can be used to go in and just block out those words, sentences, or paragraphs from a document on the computer before it's provided. This is much better than using whiteout and then making a photocopy or a black marker to strike that information and then photocopying it so nobody can hold the paper up to the light and see what was once there. So these are different types of software programs that are available. There's many different things that are out there in the computer world in forms of technology to help with your particular legal practice. Billing software is a huge help to law firms. There are two examples here of billing software that are used by many of the legal practitioners in the Lehigh Valley. One is Clio and one is LawPay. There are some demo videos under the timekeeping chapter under learning content for this particular lesson that you can take a look at. But billing software is definitely practically a necessity in this day and age for a law firm. And what will happen here is when you're keeping your time as a timekeeper, and I'm keeping my time as a timekeeper, as we discussed in earlier lessons, all of that information goes into the client's file, and this would be within the billing software, and this will generate a bill, letting the client see on the bill all the legal services that were rendered in their case, by whom, a description of exactly what was performed and how much time that took, and the cost for that particular item of legal services, all of the costs associated that were billed, such as court reporter fees, expert witness fees, photocopying, legal filing required fees, and things like that. So you can go through the demonstrations on Blackboard and take a look at the examples of this billing software. The internet is a wonderful thing for us in the legal world. Legal research was completely transformed by Lexis and Westlaw. When I was in law school, I still was being taught to perform legal research in books, and we had about maybe 2 weeks of exposure to Westlaw and Lexis as the newfangled legal research tool that might take off someday. And boy, did it ever take off. So right now, that is your primary method of performing research, is through systems such as Westlaw and Lexis. Court websites now are also readily available online. Years ago, we had to buy a book of local court rules, but now you can go on, for example, the Northampton County Court of Common Pleas website. You can see different local court rules, administrative orders that are on there, scheduling for the court. You can see what's being scheduled in different types of cases. You have the entire court calendar that is on there. I invite you to take a look at the Northampton County Court of Common Pleas website and just look around and see the different types of information that is available to you on that. And this is the end of our rather short lesson this week. However, there are quite a few video demonstrations of different types of software that I'd really like you to take a look at. Post it on Blackboard under Learning Content for Class 11. And there is a very brief discussion board activity associated with this lesson after you review those particular videos. Have a great week.